when you look at valuations, is how do you value it? And even if how do you value it and you arrive at your value, the next question is, well, how do you pay for it? What kind of time do you have to pay for it? Will they allow a stalled phased payment arrangement or something like that on the shares?
Welcome to Financial Foundations with Thomond Asset Management. I'm Neal Kelly, founder and director of Thomond Asset Management, and today I'm joined by fellow director and founder David O'Neil and Hugh Clohessy, principal of Clohessy Co Solicitors in Limerick. Today's discussion is really going to centre on business succession planning. This is really aimed at entrepreneurs, business owners, and some of the things they need to consider in terms of how they kind of handle their affairs in the event of the unfortunate demise of a shareholder themselves, but also to talk about preparation for the business succeeding to perhaps another family member, or even if they want to sell to a fellow shareholder or an outside interest. So I kind of look back in our days, Dave, setting up that there was probably a huge amount of naivety on our part. We didn't really think about any of this stuff. We kind of jumped into it. And our biggest concern really at the time was starting the business and getting going. We didn't really think about, what happens if. I don't know whether that was naivety or maybe perhaps ignorance, but essentially, we jumped in, and I'm sure that's pretty much like all, most business owners. Firstly, you, Hugh, the business owner, how, are those structures, the best way to protect the business interests, or I suppose the succession to heirs, family heirs? Are they should we involve the heirs in the conversation when setting these up, or should they be involved in the process to kind of ease that succession?
Well, it'll depend on the viewpoint of the person who has the business and what do they actually want to do it, because there are some business owners who may take a view that the family either don't want it or may not be in a position to take it over, or may not have the money in the future to buy their interests if there's some sort of value to their interest. The first step would always be for the business owner to sit down with their advisors, their financial advisors, their tax advisors and their legal advisors, and really work out a roadmap. The first question always is, what do you want to achieve? What do you want to do? Because there's many owners out there who they don't want to leave it to their kids. Sometimes it's very burdensome. Other times it's not in their interest to leave it over. Some people say, well, look, and we're talking about two different types of succession here, obviously. One is death and one is non-death. In the event of death, it may be more likely that someone says, I want to leave it to my family, and you try and see what kind of structure is that going to be. Tax advice is very important there. If it's a non-death type of event, then you're looking in probably someone saying, do I want to get value for my shares? And if I die, or if I don't die and I want to sell my shares, if I want to sell my shares while I'm alive, do I want to give my kids, for instance, an option to try and get those shares first, or buy those shares first before I exit and I get some value for it? Mm-hmm. Very often in a corporate structure, what you'd find is if there are other existing shareholders outside of family members, which is quite common, the other existing shareholders, they may want the option to acquire those shares first and take control of a company, for instance, before it goes to the kids.
Yeah. Okay. Dave, in the unfortunate situation, a shareholder, a director passes away, it's not unlikely. How can they ensure the continuation of the business, or even to protect the family, the heirs, the spouses? It's an important point, just even take it from our point of view.
Yeah, well, absolutely. I suppose as you elaborated at the beginning, 90% of companies when they start up, and especially in the first 5 years, it's probably the last thing on their to-do list, because getting up, getting running is obviously number one under that, but it is hugely important. And I suppose business insurance can be complicated because people misunderstand it, but the most commonly used product is a corporate co-directors. Now, there is a co-directors, but it would normally be, to me, partnerships, where it would be the life of another, where you would pay personally for a life shareholding policy for me, and I would pay for you. But the most common one is corporate co-directors. The problem with it is most people don't really understand the 7 stipulations that apply to corporate co-directors. And when a limited company pays for a life insurance policy, there is a lot of advice that has to be got before it's set up. But it is the most commonly used product on the market. And what that does really is it has a buy and sell agreement within the product, which means that in the event of, I'll use myself, my premature death, the Thomond Asset Management has to buy my shareholding when the money is paid to the company, and my estate has to accept that, right? It's obviously advisable to get legal advice in there, And it's based around 90% of the cost of the shareholding. A lot of companies out there that don't have it, like we didn't have it at the very beginning. The biggest problem you have is you never think about the funding element of it. What happens if a shareholder passes away? Well, you didn't go into business with his estate or his sons or his wife. And that normally can bring huge conflict into businesses. And most people, especially in that infancy period where they think about it the least is when they should be thinking about it the most, don't have the funding or the wherewithal in which to buy out that shareholding. So it is hugely important, I suppose, A, to get advice on it, and B, to make sure that you don't mix it up with other types of business of insurance. I can give you an example. A few years ago, I'd come across a situation where I was brought in. And when I drilled into it, it was not a corporate co-directors that was set up. It was a key man insurance or a key person insurance. And they thought that policy was going to buy out the shareholding. There was no legal agreement with it. And what it is what it sounds like. It's to cover just a key employee, could be a managing director or whatever. And, getting advice on setting up the right structures is hugely important. To me, corporate co-directors is something that is the first stepping stone, especially for businesses in the first 5 to 7 years. It's not that expensive and it should be done straight away,
In terms of, these types of insurances, we get a lot of questions in terms of taxation. I mean, what are the tax implications? Probably more in terms if it's done incorrectly to an estate, a business owner, what would be the tax implications, or how should they consider it?
Our old-fashioned friend, tax. I suppose, look, tax is, when you set up these structures and they're set up correctly, you can use business relief, which is 0% tax, which means that the shareholding can be bought out with no tax to the estate. If you decided to go down a road, let's even say beyond this, where you were going to retire and take out your shareholding, you can avail of entrepreneurial tax relief, which means you only pay 10% tax. Or you do nothing at all and it's set up incorrectly and you pay 33% tax. So the tax implications here are quite high, from 0 to 33%, depending on what advice you got or didn't get at the time. So it's usually problematic when people don't have proper structure in place. If I'm setting up an insurance policy for a limited company in the morning, I think it's imperative that you tie in their solicitor and their tax advisor so that the three people are singing from the same hymn sheet and the policy goes in place. Because it's not an everyday occurrence. When you normally set these policies up, you're setting them up long term with a 15 and 20 year view at a minimum. So therefore, unless the company substantially increases in value, you're not revisiting. So my attitude is always do it once and do it right.
And that, David, actually brings on, it's a very important point, is about value. That if you have a value in a company, the important question is, well, how do you value it if someone wants to get out or someone has died? Because, theoretically, someone will buy it or someone will want to sell it. And if that's an estate, the important thing for the estate is going to be, well, how much are the shares worth? Yes. And can I get the money out of it? Because, if there's no money in the company, then you're dependent on other shareholders, for argument's sake, having money. And if there's no money there, then that's just going to be a practical answer to that type of problem. Yeah. When you look at valuations, is how do you value it? And even if how do you value it and you arrive at your value, the next question is, well, how do you pay for it? What kind of time do you have to pay for it? Will they allow a stalled phased payment arrangement or something like that on the shares? They're important questions because it leads back to, if there's no money there to acquire the shares that are up for grabs, then you're effectively a stalemate. And what that will lead to potentially is, in the case of a spouse, I think where Dave mentioned, is that a business owner is now in business with someone whom they never had any intention of being in business with, and someone who may not be overly familiar with or familiar at all with the business itself. And that can cause a lot of friction.
And could that lead the spouse to insist on selling the business?
Ultimately, it can. I mean, if the two shareholders don't get along, and someone wants to get out, and this can become particularly problematic where there's actually value in the company. If you might have one shareholder who's saying, I don't want to acquire those shares, I don't need to because I have 50%. You have another shareholder who wants to exit, their spouse, their partner is now deceased. They've no connection to the company, and this is just an asset they want to realise. That can create huge friction and sometimes can lead to people visiting the High Court, which is...
So Dave, in terms of passing the business on, or a shareholder retiring, or passing it on to a family member or fellow shareholder, what are the taxation implications? Is there any structures or any things we can consider in terms of release that a shareholder or business owner should consider in that circumstance.
Outside of premature death.
Outside of premature death, I mean, we always talk about that, but that's not necessarily always going to be the case. Most people will get to a point where the business is passing on.
Yeah. There is. I suppose there is business relief, which is, and it's been extended in the budget there last year up to the age of 70 now. It used to be 65, where a person liquidating his shareholding out of the company if he's passed it on to his, let's say his child, or if it's a family business, or selling it back to a business like our own, where we would be unconnected shareholders. They can get up to €750,000 tax free. Now there is a few stipulations. They have to be minimum 10 years in business, and over 55 years of age. So it's important to get advice around these things. But yes, 750,000. If the business has a higher value, you can avail of the entrepreneurial tax relief, which is up to €1 million, and that is taxable at 10%, which is still quite lucrative. Outside of that, really, that's pretty much all you can do. A lot of people, if you give an example of that, if the business is substantially worth a lot of money, it's a situation of availing of the reliefs, pension funding, and then.
But it is important in that instance, though, to speak to a tax advisor, because there are huge amounts of stipulations, for you to become eligible with that. Again, back to the point, seek advice.
Correct.
We can't really just run off and do this.
Without a doubt. A lot of these business reliefs are built for SMEs. Businesses, which is probably the backbone of the Irish economy, businesses that will always go to a value of a couple of €1 million. But when you start to go up to the 10 million euros and stuff like that, you're in a whole other stratosphere there. From the point of view of advice, you really do need to get your legal team and your tax advisor in there, because you do run out of a bit of road at that stage. But for 90% of the businesses out there, which is really what this conversation is about, they really won't get to that type of a scenario. If you take our own example, with €1 million entrepreneurial tax relief each, your business would want to exceed €4 million if you're 4 shareholders. So they're the major milestones and tax reliefs, which to my own knowledge are quite good in Ireland. And I think that if most people could avail of them in line with pensions and everything else, it can make setting up a business.
And the thing we find is a lot of people are really unaware of it, and they're really unaware of the requirements to kind of meet this.
Absolutely. They have no understanding of it, and especially back to the infancy thing, it's not something you think about at the beginning, but you'll definitely think about it in the middle, and you most certainly will think about it at the end.
Yeah. Okay, so a business owner, right, we've tweaked his interest, and he now needs to seriously consider this as a strategy, a plan he needs to put in place. I mean, is there, what legal instruments, structures should they immediately review, consider setting up? I mean, if they were walking into your office in the morning, what should they be looking at? What should they be putting in place? I mean, and I do mean beyond the financial, potential business insurance, but I mean, in terms of the legal agreements, what should they be looking at?
Well, if we're talking about death, I mean, the first thing you need to look at is a will. Set out your wishes. What do you want to happen in the event you're not around? Second to that, if you have an interest in, say, a limited company, I would say sit down with your advisors, your tax, financial and legal advisors, and work out, what do I want to happen, my interest in this company, if I'm not around? Or what happens quite commonly is if I need to get out. So for instance, there's been a relationship between existing shareholders and that's actually broken down. Is there an ability for someone to get out of the business and actually to get value for it? But to go back to succession planning, I suppose, in the traditional sense of someone has died, your will would be very important. And then you need to look at a shareholders agreement if there is a limited structure in place. If there isn't, if it's a partnership, for instance, which is quite common for property investment in Ireland in particular, then is there a partnership agreement? Does the partnership agreement cater for one partner dying? And if they do die, then what happens to their shares in the partnership?
Yeah, okay. Well, okay. So I know for a fact from our own point of view that, we thought about this a number of years into the business. If you were advising a budding entrepreneur or even a business person today who has absolutely not considered this at all, what actionable tasks, Dave, do you think they should undertake? What should they do? Okay. Where should they start?
I suppose the first thing is you start with a conversation and you come and meet your advisor. I suppose you've got to look at it from the point of view of reversing the liability. Think about the scenario when you don't have anything in place, right? When you start with that, it's just unthinkable, because as I said, you said earlier, you don't go into business with people's estates, sons, daughters. Plus, when you go into multiple shareholders, if you take us for example, we were started out as 4 different shareholders, 8 completely different age brackets, which are standard in the business. You know, you got those variations, different outlooks in life.
We had a very wide age group with multiple things.
100%. But it's very common.
Things change over time as well, you see.
Absolutely. And you see, I suppose from that point of view, my first thing would be to look at the simplest ways of doing things. Find a problem, then find a solution. The solution, start with the easiest solution. And it's never something that it's a one fit all. So if you take a scenario where you say, right, okay, it's some of the directors are young, corporate co-directors insurance, it won't break the bank, it does exactly what it says on the tin. But then you come along and for whatever reason, one of the health of the directors, they're uninsurable. Now you got to put a plan in place, which is a longer term plan and a legal agreement tying your solicitor. This is what I said earlier, you have to tie everything together. Where the solicitor gets tied in from the point of view saying, right, we have a legal agreement here. We're going to honour what the shareholders agreement has, which is a legal document that you should be putting in place anyway in your limited company. Tie it in with the corporate co-directors. And an example would be the business is worth €1 million. You have corporate co-directors for 250,000 for 3 of the 4 partners, and a legal agreement that the other person will get €250,000 in the event of his demise or early premature death. There is a tax efficient way, but again, that ties in with that can be done and it can be paid over a period of time. It's very, very costly, especially when you're in an infancy in a company. And also the corporate co-directors insurance, when it's set up, needs to be reviewed every 3 to 5 years, especially if the company is expanding.
The value of the business will change as well over time, hopefully as well.
I could say that wholeheartedly as an example of Thomond Asset Management, and I could say it to you over the 5 years, the 10 years, and the 15 years, that's what happened. I can also say it as a financial advisor with multiple clients that I've seen that play out across the country in different businesses. And our scenario, although it's unique to us, isn't that unique at all. And so it really is, start with the basic stuff, the corporate co-directors, the stuff that is cheaper to put in place, but you have to be prepared then to put plans in place for sensation.
So yes, so Hugh, I mean, you know, a client comes into you. I mean, you know, what actionable item would you immediately advise them to do? I mean, you know, David, we've dealt with the financial aspect of it, but I mean, that's one element of it. You know, at a very basic level, what would you advise them to do?
Well, the first step would be if we're taking a early stage company, startup company, just for example here, would be to try and get everyone together and try and work out a roadmap and find out what do people actually want, because sometimes it's very surprising to find out that there's very, very different expectations of what some people want when they're setting up a business. Yeah. Some people set up a business because they want to have a big exit in a few years, make the money. Others don't. They say, well, I'm now setting up a business that I'm going to work in for a very long period of time. So working out the expectations is actually really important, because that can very often turn up that there's actually quite a big difference between what you and I think about if we're working a business, and that can become quite problematic, because the later you wait on it, and if the expectations aren't aligned, then it becomes a bigger problem, because now you have people who might have 2 different views on the world, how the business should operate, where is the business going to go, are we going to dispose of the business, and now you have a business which is potentially worth a lot more money than it was, and even in a short time prior to that. So what I would say to people coming in first would be to work out what it is that you think you want to do, what framework do you want to put around your business, and the real key ones are always, what happens in the event one of you dies? The next one would be, well, what happens in the event that one of you wants to get out? Because I mean, you might need to get out of the company, you might need to realize money of your shares, there might be irreparable relationship issues between the two of you. You just can't get on with the person you're now working with. That happens every day of the week. And what you want then, if you're looking at some sort of legal agreement, is to put a structure in place that, to the extent possible, and you can't cover off every eventuality, is not possible, but to the extent possible, it will give people a framework to try and resolve their positions without the necessity to spend huge sums of money on litigation trying to resolve their dispute. So conflict, it ends up in a way of being conflict management. And when you talk about these types of agreements, like, I would very often describe them as they're a type of divorce agreement. Yeah. Right? You sign them, they should be stuck in a drawer. If you're taking them out at some point in the future, it means that there's either a problem or somebody is thinking about a problem.
And is it advisable to review these things, on a regular basis? I mean, surely, things evolve. I mean, you can't just, as you said, just stick it in a drawer and forget about it. Oh, that's sorted, I'll pull it out, dust it off. even when. I mean, is there how often should they review it? Is it something you would recommend, that they come back to you and discuss it again?
Yeah, I would say every 2 or 3 years they should
Really,
take
2
it
or
out
3
and
years,
review it. Yeah, it depends on the business, because some businesses can change quite dramatically over a short period of time. Some people, I mean, if you take an early stage startup company, for instance, traditional example would be, a lot of the people may not have children at that point. 3-4 years down the line, now all the shareholders, or some of them, are actually their families, and they have more considerations, because now they're thinking about, well, if I die, how does my estate get the benefit of the value, that I've worked 24 hours a day for the last 3 years to actually participate in this company and create an awful lot of value for it. How does my estate get the value of that?
Yeah. And there's and valuing, as you said, valuing these businesses, you've got our little behavioural betas that people give their heart and soul to businesses, and their values can be substantially, there's calculations, there's 3 calculations that can be used. Most people will find, and it's important because there's tax implications. You can't just turn around and say, my shareholder is worth $1 million or $2 million. And you're like,
based on what? Yeah.
Based on what? Yeah. Based on the effort you put in over 20 years, or based on real hard facts? And you do see in certain instances where businesses, and it can work both ways. They start out with a corporate co-directors of $250,000, and the business has quadrupled in value and no one has visited it. Now, then if something goes wrong, nobody is going to accept that money, buy or sell agreement, and you are getting into litigation. So the rule of thumb is that every few years you do revisit it, but the shareholding has to be realistic as well. It has to be valued at, normally by its IPIDA. There's a couple of factors that would, and look, a bit of goodwill, but realistically, from a taxation point of view, you can't turn around and get more than the shareholding is worth.
So there's no doubt this is a very complicated, area of running a business, often unconsidered. And I suppose the true message is that you do need to seek advice. I mean, we although we're knowledgeable in certain areas, we sought advice for our own business as well. And, you can't do this by yourself. And you are right, guys, we have to involve our tax advisor, financial advisor, and legal advisors. Anyway, guys, thanks for your time. We appreciate it. Quite informative. And hopefully, we'll give some people some food for thought.
Perfect.
Anyway. Great. Thanks very much.
Thank you.